3 Latin American countries have offered him asylum: Venezuela, Nicaragua, and Bolivia. Meanwhile, the debates over his actions, over the NSA surveillance programs, and over the balance between security and privacy continue. Joining me now from Memphis is Philip Mudd. He's the former Deputy Director of National Security at the FBI and of the Counterterrorism Center at the CIA. In Washington, D.C., Mark Rottenberg, the Executive Director of the Electronic Privacy Information Center, the group that filed a petition at the Supreme Court today challenging the Foreign Intelligence Surveillance Court's authority to approve collection of phone records. And Jesslyn Raddick, she's the Director of National Security and Human Rights at the Government Accountability Project. Also, James Bruce, a senior political scientist at Rand Corporation. He was formerly a senior executive officer at the CIA. Here in New York is Timothy Murphy, former Deputy Director of the FBI. I'm pleased to have all of them on this program. So welcome. Let's start with you, Phil Mudd, because I know that your time is short and you're going to have to leave us before our other guests. One of the questions that Mark Rottenberg and Jesslyn will raise is, as they bring these court challenges, is there really a need for a government agency like the NSA to collect every phone call made, every telephone number dialed and received across the entire United States, and call that, in a court order, possibly relevant to a terrorist investigation? How exactly does that work to somebody who needs an explanation?
Well, I think you should take terrorism out of the question here. In the 21st century, whether you're looking at organized crime, gang networks, or terrorists, you're looking at people who leave an increasingly digital trail, just like I leave every day. ATMs, instant messaging, phone, email. So if you want to understand the network around a conspirator or a potential conspirator, it's hard to imagine understanding that network without accessing their digital trail. And
people would say that, I mean, the argument, I guess, Phil, is that once that trail is started and you have your bad guy, suspect, terrorist, cyber crook, whoever it is, you start with that, and then you figure out how to get those records after you have, your starting point, rather than just collecting everything. That seems to be the counter-argument to the massive vacuuming of the digital trail.
I suppose so, but you're also going to have questions about technical issues like storage. For example, if I'm sitting at a threat table and somebody by the name of John Doe comes up in the threat scope, I'm going to want to know not only what he's doing today forward, but what he was doing a year ago, 2 years ago, who he was talking to, where he traveled, what he charged on his credit card. I want to draw a picture of a spider web around the spider in the middle of the network so I understand everything he was up to, going back potentially several years.
All right, well, Phil Mudd, I know that you have another appointment and you're shifting off to that, so sorry to lose you in that way, and thanks for joining us and really setting the baseline there of, from an analyst standpoint in the age of terror, what all this about. Now, Mark Rottenberg, you filed suit in Supreme Court today against one of these core programs. That's the court order asking for every phone number dialed from Verizon on a rolling basis. Tell me what you did and what that order is asking for.
Well, the key point that we've raised in our complaint to the Supreme Court is that there was no legal basis for the Foreign Intelligence Surveillance Court to require Verizon to provide all of the call detail records on all of its customers on an ongoing basis. We simply don't believe that Congress gave the court that authority. And if we are correct on this point, and I think we are, then that order has to be vacated, and the program, at least that aspect of the program, has to be suspended. It's a particularly interesting issue for the Supreme Court, because this past term, the court considered FISA misuse when no one was able to present evidence as to the possibility that such misuse had occurred. And without that evidence, the court ruled narrowly, 5-4 against the petitioners, that the case could not go forward. We have something in our petition that did not exist in that case, and that's the actual text of the order. The court has the opportunity now to look at the order that was signed by that judge and make a determination. Was it legal? If it wasn't legal, the program has to be suspended.
And the argument from the other side would be, well, this is access to metadata that would be used on a case-by-case basis, not access to actual names or U.S. persons or something that would be considered privacy, I guess the argument would be by its sheer volume, it gives anonymity. You don't buy that?
Well, let me say two things. First of all, we spent a lot of time in our petition describing the scope of the metadata using the actual terms that the court had used when it told Verizon to provide this information. I think people who have the opportunity to look at that text will reach the same conclusion we did, which is extraordinary. I mean, it's unprecedented to imagine that so much information could be provided on all customers engaged in solely domestic communications. But let me make a second point, which is that the government may have an argument that it needs the authority to do this, and that debate could take place. But that by itself is not a justification for continuing the program. In other words, if Congress didn't create the legal authority for the government to do what it's currently doing, then the government has to pause, and it has to come back to Congress and the public and make that case. And I think that would be a great debate. I think we should have that debate. I think that's the debate that the President has proposed.
Tim Murphy, former Deputy Director of the FBI, is somebody who's been in the room in the Strategic Information and Operations Center during a terrorist threat crisis situation. Does that order seem legal, and does it seem necessary? I mean, people would ask, how do you use that much data?
Right. I want two things. One, legal. I think we have to have this debate on the difference in the balance between the civil liberties and privacy, and what we need in intelligence circles and law enforcement to actually keep this country safe. Not go back to the days where we just weren't connecting the dots and doing the things we need to do. But I do think there's a danger. I believe in the debate, but I do think there's a danger in stopping the collection at this point. I mean, they've had some declassified cases that they've shown the American people, they've shown Congress that this program has helped protect this country. It has helped stop terrorist attacks in their tracks. So there's a great danger, I believe, in stopping this program. I don't disagree that there shouldn't be a debate. We shouldn't evolve this program. I mean, that happened if you look back with Deputy Attorney General Comey and the Director of the FBI. They certainly weighed in and changed the course when this was first, brought out and put across the government, and the Department of Justice understood the scope of this program as what was happening under the prior administration, and they stood up and changed the program.
The question is, everybody seems to be agreeing to some extent with Mark Rottenberg saying it's time to bring this out for a discussion with the American people. So I guess the question is, why did it have to all be secret? Why didn't this debate happen first?
Well, that obviously is it's a very good question. But, the point is that in intelligence, we're in the process of evolving over time. If you go back to the way intelligence was collected years ago, we've really seen an evolution. So there's been continuity and change. Phil Mudd used the expression digital footprint. I think this is a whole new concept. I think there is an exaggerated understanding about what NSA collects and what CIA collects and what a lot of other intelligence agencies collect. Actually, I think the problem is really more limited information than having too much information. Now, the question of whether or not there should be a debate, I heartily agree. There really ought to be a debate. I really don't think there's much of a debate, at least in my mind, and I'm not a lawyer, about whether or not the government has the authority to do what it's doing. These are entirely legal programs. They've been fully authorized in law. These are programs that are subject to a considerable amount of oversight. And so we can have a debate about whether or not the government should have this authority, and I think that's probably where the debate will go. But in the end, it seems to me that what you really have to decide is whether or not this country is going to have the kinds of intelligence capabilities it needs to provide the protection that the American people want and deserve. Okay. And if we're going to have good information to provide decision advantage to American policymakers, we just have to have some capability to collect intelligence against those who would want to harm us.
But I read your piece in Studies in Intelligence that said, and let me just quote this line from it, it was an extensive piece on the proliferation of leaks, the use that our adversaries make of leaks, the increasing danger of leaks to the intelligence community. But you write in one part, and then I want to get to Jesselyn to react to this, government officials, journalists, and publishers who are found to be in possession of documentary classified intelligence should also be prosecuted under the federal law for possession of stolen government property. So the conundrum here is, on one hand, it's good that it's got out because it'll fuel a discussion. On another hand, you believe Edward Snowden should be in jail, and so should be the reporters who published this. That's a bold statement.
Well, there's obviously room for a discussion and debate on what kind of legal protections extend to publishing companies and journalists who claim the right or presume the right that they can publish classified information. Of course, that's not a right that's ever been established in law, and there's no constitutional basis really for saying that anyone has the right to publish classified information. What we do know about classified information is that it is government property, and it was established in the Morrison case that when classified information is leaked to people who are not authorized to have it, and of course we refer to those as unauthorized disclosures, then those who are in possession of classified material have no authority to have it. So then the question is, are they in violation of the law? Now, here's where you can get into a good debate about what the law covers and what the law does not. And in my view, I believe our current, and this is really part of the argument to, yes, let's have a public conversation on this. My view is that the current statutory protections for government intelligence collection are inadequate, and I believe that we need to have a comprehensive statute that addresses the issue of unauthorized disclosures. Right now we don't have that, and when government officials look to some legal framework to help them deal with this issue of unauthorized disclosures of classified information to people who should not have them. And by the way, the people who should not have them include Al-Qaeda and terrorist organizations and others who are threatening to do harm and do harm to this country and to its allies. Then it seems to me we have to deal with the question of what sort of legal protections does the government require to be able to be able to do this? And the issue, it seems to me, is how to provide that. So part of this conversation, part of this national dialogue that we have, shouldn't just be about the issue of privacy. It should also be about the added measures that the United States government requires in order to protect the capabilities it has to provide the intelligence it needs. I'm not talking about all leaks of all classified information. What I'm talking about is the kind of classified information that does extraordinary damage to the capabilities that this country has to conduct intelligence and, frankly, to conduct wartime operations and diplomacy.
What do you glean from what you're hearing here?
What I'm hearing is basically a desire to criminalize whistleblowing and criminalize journalism. And in terms of statutory authority, there are at least a dozen different laws that could be used specifically for the unauthorized disclosure of classified information. But you cannot properly classify something that is illegal. And what has been revealed by Mr. Snowden violates at least two federal laws governing surveillance, FISA and Section 215 of the Patriot Act, but also the Constitution, which nobody has brought up. What authorizes the press to do what it does? The First Amendment. And I've represented an NSA whistleblower, Thomas Drake, and he went through every proper internal channel. Some of your other guests talked about that's what a real whistleblower should do. He did, and not only did that not achieve anything, but the government turned around and prosecuted him for espionage. To make that worse, the case ended up falling apart because all of the government's evidence was not properly classified. It was all completely unclassified.
When you change channels to Snowden, you've got leaks that could fuel this debate about what is the level of privacy versus security. That's arguable. But then you have other leaks where he's saying, here's how we collect on the Chinese, here's how we collect against the Russian leadership, here's how we work with the Germans. These are the things that, if you were talking to James Bruce in the next box, he would say, these are the kinds of things that do damage to our ability to collect intelligence against serious adversaries around the globe. Do you buy that?
I don't. I mean, every time
Why
it's a lot
not?
of fear mongering because the government puts up cases like the Zazi case, where it turned out there was nothing really there. It didn't help foil a terrorist plot. It was something else entirely. It was not electronic surveillance, and doing mass dragnet surveillance on every single person on the planet is not legal, constitutional, or ethical in any kind of way. It's a surveillance state, which we fought a revolution against to become the United States. So I understand why other countries are also apoplectic about this. The ones who are being surveilled and the ones whose people are being surveilled by our country, as well as the people who already know that they're being surveilled. Again, the problem here is not surveilling foreign to domestic. That's okay. But the domestic to domestic surveillance, that is not okay. And I think that is what the vast majority of Mr. Snowden's revelations reveal.
So, I mean, Mark, one of the things that comes up is when you look at the polling data, and it's hard to tell whether this is because of a lack of information or part of a post-9/11 sentiment, aside from the most vociferous voices in the privacy and civil liberties community, the numbers show the basic majority of Americans, not a vast majority, but the tilt is there, say, I'm not as upset about this as everybody was screaming about it. Why do you think that is?
Well, let me say, I read these polls closely, and almost every question asks the American public, are you prepared to sacrifice some privacy to prevent against future terrorist acts? I would probably say yes to that. But that, in fact, is not what the government program is about. It is far more expansive, it is far less focused, and the intrusions are much greater. So I think we need a more informed public debate, and that only happens, for example, when you make public the legal theories and the authorities, and you show the American public how much of their personal information is now in possession of the National Security Agency.
Well, I think we're going to have to leave it there. So what we seem to agree on is now that the horse is out of the barn, it's a good time to have this discussion. We also seem to see that we need to know a lot more about what the horse actually looked like and need more information about this. So Mark Rottenberg, Electronic Privacy Information Center, thanks for joining us. Jocelyn Raddick, James Bruce, Phil Mudd, who had to leave, and Tim Murphy, thanks for joining us in New York, former Deputy Director of the FBI, for a discussion which seems like it will continue.